Good afternoon, ladies and gentlemen. Our second panel today is going to discuss class actions in Mexico. And I'm going to introduce them to you. They're very distinguished and experienced folks in this area. George Priest will lead off the discussion with the discussion of American class action practice and certain aspects of Mexican law which is different, and what we can expect in both areas. I've already introduced Professor Priest. I see some of the same faces that were here earlier this morning, so I won't go through all his many achievements. He's a professor at Yale Law School, and he's been very instrumental in publications of competitive law. And this morning we had a very spirited discussion on price squeeze and whether it was good or bad for Mexico and for the United States. Next, after Professor Priest, we have Eduardo Facha, and he will lead off with an explanation of Mexican class action law with an emphasis on the certification process, which he thinks is crucial to an understanding of how the law will operate. And in that, it's not too different from what we can expect in the United States, because certification is sort of the big hurdle which every plaintiff has to get over, and if he doesn't, every defendant is very happy. Mr. Facha was born in Sèvres, France. His practice focuses on banking, civil, commercial, corporate, securities, and takeover litigation. Mr. Facha began his career as an associate in Quijano, Cortina, López y de la Torre, Abogados, where he was directly involved in numerous high-profile takeover disputes and high-stakes banking and corporate litigation. During 2002, he worked as a foreign associate in capital markets practice for Sidley, Austin, Brown, and Wood in New York, before returning to Quijano in 2003. Mr. Facha is a member of the Mexican Bar Association, Barra Mexicana Colegio de Abogados, and of the New York State Bar Association. In 1999, Mr. Facha received his law degree cum laude from the Instituto Tecnológico Autónomo de México, ITAM. In 2001, he received his LLM in Banking, Finance, and Corporate Law degree cum laude, again from Fordham University School of Law. In 2002, Mr. Facha was admitted to the New York Bar. This is very unusual that somebody whose first language is not English is admitted to the New York Bar, so chapeau. Marco Nájera will follow with a discussion of the various administrative agencies that intervene in the Mexican class action scene. And let me tell you a little bit about Mr. Nájera. Marco Antonio Nájera Martínez is the head of Garrero, Arena y Asociados in competition, antitrust, and regulatory practice in Mexico. Mr. Nájera's experience is extensive in competition law, including merger control authorizations for a number of global and local concentrations, antitrust investigations, cartels, abuse of dominance, and public bids. He routinely provides regulatory advice to different clients in other areas of law, including, among others, financial, insurance, and health. His experience is also broad in corporate mergers and acquisitions, including a wide range of cross-border and local transactions with special emphasis in joint ventures and financing. Among others, he has been deeply involved in the financial, insurance, real estate, pharmaceutical, food and beverage, and oil and gas industries in Mexico. Marco Nájera has been recognized by the publication Chambers Latin America Leading Lawyers for Business as one of the leading practitioners in competition and antitrust and insurance in Mexico. He obtained his JD, again at the Instituto Tecnológico Autónomo de México, ITAM, with honors, and has postgraduate studies at Escuela Libre de Derecho, foreign associate in the Houston office of Garrera, Wynn and Sewell, LLP, in 2008, and from 2000 to 2001, he's a member of the Mexican Bar Association and the Ilustre y Nacional Colegio de Abogados de México. Last but not least, we're pleased to have with us Luis Omar Guerrero Rodríguez, who will follow with an emphasis on Section 38 involving antitrust class action litigation, the role of CONFECO with the Mexican Competition Commission, the role of consumer actions in class action litigation, and comparisons with other jurisdictions. He will also discuss antitrust reforms in Mexico and the recent emphasis on expanding concepts of standing in class actions, where individuals' interests have not been injured, but societal interests have been claimed to be injured. Each of the panelists will hold forth for about 7 to 10 minutes with their presentation, and then we will have interpanel or intrapanel questioning, and then questioning from the audience. So we'll start with Professor Priest.
Thank you, Judge Bea. Just so you know something about my experience, I have taught about class actions, I've written about class actions, I've served as an expert witness in class action litigation, and I've also had the experience, which I'll mention again later, of managing a class action. In the U.S., it's not uncommon for a court to appoint a sort of assistant person called a special master to administer once the class is certified, to administer the completion of the class action. I've done that in a major class action over many years. And so I think I know something about class actions in the U.S. And what I want to do in my comments this afternoon is to compare the U.S. experience with class actions with the new Mexican class action statute. Now, of course, the Mexican class action statute has not been put into effect yet, and so this is hypothetical over some range. We don't really know how it's going to work out. But the U.S. experience may be, in the U.S. we've had class actions and an increased class action litigation experience over the past 60 years, really. And so there may be something to be learned from the U.S. experience. Now, the Mexican statute is substantially different and sets up procedures that are substantially different from Mexico. And so let me describe some of those differences while telling you what has happened in the U.S. As Judge Bea indicated in his introduction, as it has developed in the U.S., the most crucial moment in class action litigation is certification of the class. Once a class in the U.S., once a class has been certified, the case is generally over, largely over. Class actions seldom go to trial. There are seldom actual trials of class actions. Once a class has been certified, it is most common in over 90% of cases, probably larger than that, for the action to be settled. The reason for that is that in the United States, the class action mechanism has been used to increase the stakes of the case so dramatically. So the amount at issue, once a class is certified, the amount at issue is so great that oftentimes it becomes an issue of whether the defendant wants to bet the company, it's usually a corporate defendant, on the outcome of the litigation before a jury in the United States or not. Most defendants don't want to do that, and so there are settlements of the class action. But that means that in the United States, as Judge Bea pointed out, the great battle in class action litigation is over certification of the class. Now we have a number of, I even think they're peculiar rules and traditions about certification of the class that may not be true in Mexico and are being even amended or changed in the United States. By our rules in the United States, the judge considering class action certification, and certification is a decision made by a judge according to criteria not too dissimilar from those in the Mexican statute, commonality of issues and the like. But by our rules, the judge is not to, in the United States, is not to consider the merits of the case. But as I've mentioned, so the judge is not to evaluate the merits of the claim of the class, but just to evaluate whether the criteria for class certification, commonality, and the like have been met. As class actions, as I've mentioned, involve increasing amounts of money, however, it's been necessary, really quite necessary from a practical standpoint, for the judge to at least preliminarily make a ruling on something related to the merits. There's a substantial debate in which I've participated about whether the judge should look at the merits of the class action or not. I think the judge should, because otherwise oftentimes there's an in terrorem effect that's created by certification of the class. At any rate, within the last decade, the federal rules have been amended in the U.S. to allow appellate review of federal class actions, which gives another chance to debate certification and another chance for a different set of judges to evaluate whether this action should proceed as a class action or not. Now, that's not true in Mexico. At least as I read the statute in Mexico, and Eduardo, I think, is going to talk about this in more detail, the certification is substantially different. From the statute itself, it appears that certification, the time from a filing of a suit to the consideration of certification is extremely short, 10 days, as I read it, although there appear to be possibilities of extending it, but not extending it very long. From the U.S. standpoint, this is highly questionable whether this is going to be sufficient to evaluate class actions. In the United States, again, because of the high stakes involved in the case, the major battle is over certification, and as a consequence, there are major investments made by both sides of a case in the certification battle. Now, I know things are different in Mexico with regard to discovery, but in the United States, discovery prior to certification can take a long time, often years, where the attorneys for the defendant will depose every member, we have representative members of the class, but we'll depose them. This takes a long time. And we'll depose them for purposes of finding out whether their interests are really common, whether the legal issues that their situation raises are common or not, whether the class can sensibly be litigated, whether the issue can be sensibly litigated as a class action or not. Obviously, there are different rules about discovery in Mexico, but it would be impossible to engage in this type of discovery in the short period of time that the Mexican statute seems to allow, which will mean it will be much more difficult for defendants to challenge certification in Mexico, depending upon how judges treat it, of course, and we don't really know that yet, than it would be in the United States. That could, if other developments in class action litigation occur as they have in the United States, that could be a big problem. There could be lots of classes certified that in the United States would be challenged and successfully challenged for certification. Second, it seems clear to me from reading the Mexican statute that it explicitly envisions a difference between, or a two-stage process, a class-wide trial followed by trials of individual proceedings to determine damages or determine their situation, how close they're related to the act, the claimed harm and the like. Again, this is substantially different from the U.S. In the United States, if it is envisioned that the class action will lead or will require individual proceedings, that is looking at each individual class member, class certification is denied. That is, if the class action, to argue that the class action will lead to individual evaluations of damages would be to defeat, in the United States, defeat the idea of the class action. In the United States, the class action is based upon supposedly representative claimants who represent different groups of members of the class. And so the trial occurs over those individual claimants, but with no thought that one would look at entire members of the class. Now, again, in the United States, we have classes of many thousands, sometimes even larger than that, in, say, securities class actions. For example, the class action that I've been managing is seemingly a fairly small class action. It is, there are 7,000 class members, but it's taken over a decade to resolve all this. Of course, that's the reason the judge appointed a special master, because the judge doesn't have time to spend a decade looking over all of these cases. But this is the Mexican procedure as it seems to be established now is very different, with the thought that individual class members will have a day in court or a right to show their claim. That is substantially different, and there's a real question whether the judge himself or herself can continue to manage those proceedings. It may well occur in Mexico, as it has in the United States, that where there is a complicated class action that involves lots of individuals, that it will be necessary for the judge to appoint some other subjudicial official, like me as a special master, to actually do the legwork to figure out all that has to be done. And again, it was not considered that I would do this on an individual I mean, I had to figure out the amount of damages for each individual, but it was done by categories of individuals, not by looking at each individual case, except to show that the person qualified as a member of the class. Third difference, the Mexican statute makes a very clear distinction between class actions in which members of the class can opt in, choose to become members of the class, and class actions in which members of the class can opt out. As I understand it, if the class action involves the vindication of a personal right, the claimant is allowed to opt in. If the class action involves the invocation of diffuse rights, societal rights, the class member, or possible putative class member is the word we use in the US, can decide to opt out. In theory, good idea. In practice, big questions. In the United States, we have different class actions that involve opting in and opting out. But the opt-in, opt-out procedure, in my judgment, having seen it in practice, in theory, it's a good idea. In practice, it doesn't really work. The notice that is sent out to the individuals who are, again, we use the word putative class members, are complicated. They are legal documents. They are seldom read, because again, the individuals don't understand the legal issues. They often come in little booklets that are more complicated than insurance policies. So they're often just simply discarded. We have so much class action litigation in the United States that I receive notices that I am a potential member of a class maybe every other week. Now, I don't read any of these. I mean, I don't think if I thought there was anything at stake, oftentimes the individual, even if you participate, you get a check for $1, 80 cents, sometimes nothing. You get a voucher. The attorneys get a lot, but the members of the class get nothing. So I don't bother. I mean, my life is too short to read class action notices in the United States. But I think this is probably going to be a problem in Mexico too, because again, depending upon what the class action is, again, if it's a commercial class action where the members of the class are banks or large industries or corporations, you can hire someone to read it. But when they are individual consumers, it is not proven in my, Judge Bea may have a different experience. My experience, it is very unlikely that the individual citizens will read these notices and make intelligent decisions about opting in or opting out, as is imagined, not only in your statute, it's imagined in our statute too, but it just doesn't, it hasn't worked. Even more problematic is the provision in the Mexican statute to allow opting in for a period of time of 18 months after a judgment or settlement. I really don't understand how this is going to lead to settlements. Now we have a procedure in the United States according to which settlements can be contingent upon what happens afterwards, whether people opt out, whether people opt in. A defendant will not want to enter a settlement if a lot of people opt out to file individual suits, because who are they settling with? But they certainly don't want a settlement, or they can't determine what the amount of the settlement will be if large numbers of people can opt in for a year and a half after the settlement, because again, how do they know what to pay in that context too? I think that provision will substantially constrain settlements of class action litigation in Mexico, or it will change the nature of them. The settlements will have to be contingent upon what actually happens in the opt-in period afterwards. Finally, and this I think is a benefit, the Mexican statute has and appears to change the incentive structure for class action litigation, at least change it from that in the U.S. Now again, I don't know how this is going to work, but in the U.S. the class action procedure is not generally available to governmental agencies, as it explicitly is in the Mexican statute. So our governmental agencies have some regulatory powers. They don't have class action powers. And they don't have class action authority to actually sue on behalf of individuals and obtain damages on behalf of those individuals. Now again, I don't know how this is going to work out. It will depend upon, in Mexico, it will depend upon what the attitude, what the ambitions, what the political realities of agencies in proceeding with class actions are going to be. We don't have that in the U.S. All of our class actions in the U.S. are brought by private attorneys. All brought by private attorneys, and it's a very competitive and lucrative profession to be engaged in class action litigation in the United States. Now, Mexico has dealt with this in a way that is superior to the U.S. For example, the Mexican statute puts limits on attorney's fees, depending upon what the level of recovery is, that are substantial, that make potential class action attorney's fees in Mexico much less than attorney's fees in the U.S. For example, the different percentages, 20% for the first 200,000, 11% for the first 2 million, 3% in excess, are vastly lower than what is routinely awarded in class action litigation in the U.S. Now, I think this is a good thing. I've also testified in a lot of class action attorney fee cases in which I am quite certain that attorneys in the U.S. are overcompensated for bringing class action litigation, because they typically are awarded a substantial share, oftentimes the 20%, 18, 19, 20% of very large class actions, where after the certification hearing and the certification of the class, they did next to nothing else. All they did was negotiate the final dollar amount with the defendants, where they had a gun to the head of the defendants because of the certification of the class. So I think this is a good thing. One could argue about what the numbers are, but it will, the lower legislated limits on attorney's fees in Mexico are probably a good thing, not a bad thing. One last point, the modified loser pay provision of the Mexican statute is in theory a good idea too. We don't have that in the U.S. That's not a feature of the U.S., but I don't know how easy or how effective it's going to be in practice. That is, what does it mean for the loser to pay? Maybe it means, but this would have to be under supervision of the judge, that the attorneys for the putative class take on the responsibility of paying all the costs, all the loser pay costs. Sometimes that's done in the U.S., but we don't have loser pay in the U.S., so the attorneys don't mind taking on the obligation of paying the expenses of the class, but they certainly aren't going to pay the expenses of the defendants in defending the class action. If loser pay, and I don't know how this is going to work out, and I'm interested in hearing from all of you, because all I've done is read the statute, and I don't know how it's going to work out. But if loser pay means members of the class have to pay, well, it just is not going to work. I mean, it's not going to be possible to, if you have, again, a consumer class action, lots of poor individuals who claim to have been harmed, but then are found not to have been harmed, is it really realistic? You're going to collect the costs and expenses of the defendants from this poor class of consumers? It's not, I don't know how it would be handled, but it's not going to be, it's not likely. And there have been proposals in the U.S. to adopt a loser pay provision to, again, try and constrain the nature of class action litigation. But it's been I think, widely accepted in the U.S. that that's not going to be effective either unless the attorneys sign on. And why would the attorneys sign on in that context if they don't have to? And if they haven't done it, you're not going to collect against the members of the class for these attorneys' fees in any serious or effective way. Even if you had judgments against them, you're not. What does it mean to levy a judgment for some share of attorneys' fees on a poor consumer? I mean, it's not effective, it's not cost effective, it really doesn't make any sense. So it's going to be, so from the standpoint of an American, it will be very interesting to see how the statute works out in practice, and I'm looking forward to hearing from the other panelists to give me their predictions.
Thank you very much, George, and now we'll hear from Eduardo Facha with an explanation of Mexican class action law.
I think we need to make a general reflection to make the best out of the other issues that we will briefly discuss concerning what has been said so far. Mexico is, as opposed to the U.S. or in difference to the U.S., is a codified system. The U.S. is a mixed system. You have statutes, and you also have a common law tradition, which is very important. This common law tradition, as you probably are aware, allows for the efficient regulation in the U.S. to be modified in a very dynamic way through the decisions of the judges. And the bottom line of this difference is that when you have a defective statute, assuming you have the proper controversies presented by the parties, the judges will have a huge opportunity to, through the decisions, shape the right interpretation of these statutes or what they really meant. And if the statute is so defective that does not allow for the proper interpretation, that does not violate higher laws like the constitution of a state or a federal law or a federal constitution, then the judiciary is able to pronounce the ineffectiveness of the statute. And you have Congress immediately reacting to that because because of the generality that you can have within a certain circuit of a federal decision from a judge in the U.S., you immediately have to act to enact a rule that fills a void, so to speak. Mm-hmm. And so the system is made in such a way that it's not so susceptible to a defective statute. Mexico, I believe, is much more vulnerable because of the codified system, which is more static, and because of the way jurisprudence and mandatory case precedents have to be formed in Mexico to be mandatory. It makes it more slowly for the Mexican judiciary to reshape or get to the proper interpretation of a statute. Now, in the case of the collective action statute, as was rightly pointed out by my colleague, George, yes, by George, by Professor George, has some differences that are, as a civil attorney, I was very encouraged when I heard that Mexico had enacted this statute. But once we began review of it, there were some issues that are of great concern, in addition to the ones pointed out by George, that leads me to the same conclusions that in certain aspects of this new reform, there will be issues that will not fall into place in the way that legislators had it in mind. This statute is based on the experience in Brazil. The Consumer Defense Code of Brazil, enacted since the 80s, early or even before that, late 70s, some of the provisions that we see almost to the letter in this reform. And therefore, I think Brazil picked up on some of the ideas that were shaping, according to Rule 23, which is the federal U.S. rule that shaped this collective actions act. That's right. But they made some of the modifications that when they were brought to Mexico, I believe it's going to be problematic in some instances to get to the point where a defendant will know whether or not he's facing something of a liability and of a kind of risk that would allow for a settlement that would include the fees that Professor George was mentioning. Now, the main issue with respect to certification, which has already been discussed, is similar to the U.S., the Brazil statute and the Mexican statute provides for 4 or 5 requisites, which really are referred to standing of plaintiffs to enact these class actions. The requisite of commonality, which is, regardless of the type of class action, we will go briefly into that, there has to be enough common issues with respect to a class to justify that the class can bring up the action. Numerosity. In Mexico, we decided that that number would be 30. It's funny that it was limited to a specific number. In the US, it's on a case-to-case basis. If a certain class is small enough that it cannot reach a 30 number of individuals, it nonetheless may be considered a class if it's 28. Because of the type of class, you cannot think about a bigger class. In any event, the numerosity requisite in Mexico was brought down to 30 people. But then there's one procedural issue with respect to procedural standing in Mexico, which really concerns me, and it's on, you will find it on subsection 4, subsection 5 of section 589 of the reforms, which says that the proceeding, if it's going to be with respect to a collective action, if it's ideal for purposes of resolving the issues and repairing the damage of the collectivity. The language of this provision is so general that when the judge receives the collective claim and has to, within 10 days, well, first of all, what the judge does is he will give a 3-day period to the defendant to present a motion with respect to whether those requisites are fulfilled. And then the judge has 10 days to decide, which he can only extend once for 20 days. And among other requisites, which, like Professor George said, may take many days to duly have an opportunity to demonstrate whether or not they are met, this single issue could lead a judge to decide that individual action by each member of the collectivity is better than having the collectivity present the action. And on the list of things that may make the judge think it is not ideal, Professor George just mentioned 3 or 4 things that could be enough for a Mexican judge to say subsection 5 of section 589 is not met, and therefore the action is not, I'm not going to let it in, I'm going to dismiss it. And there's a single appeal, whether the action is, the certification is met and provided by the judge, or the judge refuses to allow the action because he deems that the requisites are not met. You only have one appeal, as opposed to the US, where because of the system, even after certification is met and the procedure continues, you have at least a couple of opportunities to review whether or not that certification was adequate, whether it was ample enough or specific enough. So that's one of the most important issues that really concern the reform. The second issue that was not mentioned already, which also concerns me, and has to do with the idea that, as in the US, probably litigations like this, many of them will settle depending on whether or not certification is achieved by the class. And that's why we do believe that the fierce litigation will take place with respect to that certification, is preemptive measures. There's a section on the reform that talks about preventive measures, with respect to these actions. And if you look at those provisions, you could end up with a measure, even though there are some strong requisites to establish them, and judges will be reluctant. You may have a window to enact a measure that would practically render the case for the defendant absurd to litigate, and he will have to settle immediately if that measure is issued. And you will be able to see the provisions. We don't have time to go through them, but there is one limitation to this possibility, which says that the judge has to review whether or not the enactment of the preventive measure will, so to speak, will take the defendant to bankruptcy, or no. But how can the judge, with respect to an ancillary matter, have the numbers and all the knowledge with respect to what the liability, once it's liquidated, could mean, or the measure consisting of stop selling a product which is damaging consumers. If you're talking about a company that depends on the distribution of that product, the damages you may cause, there's obviously a rule concerning guaranteeing such damages, but we've seen that in this country some federal judges have, if you have a judge who's superficial with respect to the meaning of these requisites, the analysis, you're going to have preemptive measures that are going to be so bold and aggressive that you may prompt a settlement that may be unfair to defendants or to plaintiffs because of the circumstances under which a settlement may be reached with respect to the issues. A final reflection on the brief time we have is, we have seen with respect to attorneys' fees and other aspects of this reform that they tend, as far as civil law is concerned, to regulate certain aspects that you don't see otherwise regulated in other provisions. For example, limit to attorneys' fees with respect to the attorneys that represent the class action, as opposed to the attorneys that represent defendant, which you can also think about why didn't go both ways. But I'm sure that once this enters into effect in January and we begin to see cases in Mexico, we will see a lot of filings with respect to the unconstitutionality of some of these issues. I can see many attorneys thinking about an undue limit to certain Bill of Rights from Mexico with respect to the freedom of covenants and reaching issues that should not be limited by a statute, and that will be interesting. And that's the way Mexico really is going to reshape the deficiencies of this statute through the constitutional actions available. And with this respect, I would like to leave you with a small an important reflection, a question of what happens if a defendant. We've all thought about some of the advantages and disadvantages of these actions. One of them being that you allow for a group of individuals to have a greater ability to equal the stakes on litigation with respect to a big company. But that's true with respect to big companies, and in some cases. Other cases, what's going to happen is you're going to have a middle company who's struggling to come out, and you're going to have a huge liability with plaintiffs in one of these actions. What if these companies, whether large or small, when you request a service or product that you want to consume, you enter into a contract, one of these already prepared contracts that you sign off onto, and it has a clause with respect to arbitration, whereby the possibility of initiating this action is excluded. Is that covenant lawful under Mexican federal law? Because this is a federal enactment. This concerns federal law and the federal constitution, or is it because of the public interest in Mexico? Is this the type of provision that should be respected? And that means that any covenant concerning arbitration and excluding the possibility of exercising a collective action would be deemed unconstitutional or no. Recently, the United States, we can talk about this on the other dynamics of this discussion, the Supreme Court reversed a decision from the Ninth Circuit. I believe it was a decision where Judge Bea intervened.
I wrote it.
It was a vote 5-4. The 5 conservative members of the court voted in the sense that California law banned this type of clauses, stating that the clauses violated California law, which cannot exclude the possibility of consumers exercising the class action. And the Supreme Court of the United States stated at the end of the remedy that had to review that it did not violate the Federal Arbitration Act. What I understand when I followed this case was that everybody expected that the court would confirm the decision of the Ninth Circuit, but it did not. It reversed it. Mutatis mutandi, in Mexico, we're going to have the same litigation through the procedural paths that Mexico has, but the discussion is going to be interesting in that respect. You're going to see many attorneys challenging the validity, the extent of this statute from the point of view of allowing or no to exclude these actions through an arbitration clause.
Thank you very much. We'll move on to Marco Nájera,
Thank you very much. I will speak first of one of the interesting points of the reform, which has to do with the ability of administrative authorities to initiate class actions, which, as you have well said, George, is not common in the US, and possibly this is more a Latin American practice. Cases such as Brazil, I understand. Colombia has a very interesting and quite developed class actions. Even they have a separate class actions law, and also cases like Chilean. So Mexico introduced these kind of class actions by the authorities, which do not, this is important to say, these do not preclude individuals of a group or a class to also initiate individual class actions on the same areas of law. So we will have this combination of in the same area, consumer protection, etc., where the authority will be could participate if they want, and if they could, we will see the problems here, and also groups of individuals independently trying to file class actions. In my view, one of the issues of this reform is that, in my view, it's short in terms of which kind of areas of law will allow class actions to be filed. Unfortunately, we will only have class actions on matters relating to consumer protection in different areas and in connection with environment. I would have liked to see perhaps class actions in some other areas, for instance, labor or security, government conduct, for instance, in a country like Mexico, even health. We will not have that. Really, the areas where class actions will be allowed are very narrow, and we will start living with that. As to the authorities that will have the ability to initiate class actions, we have, in the side of consumer protection, Profeco, which is the Consumer Protection Agency, Conducef, which is the Consumer Protection Agency for financial services, financial regulated services such as banking, insurance, SOFOMs, etc. COFECO, which participation will be very interesting, which is the Antitrust Commission. Profepa, dealing with environmental issues, and also PGR. It is interesting to say that in the case of Profeco, the Consumers Protection Agency, this ability to initiate class actions already existed from a long time ago. Actually, since 1975, Profeco had the ability to initiate what it was called group actions, which is ultimately a similar concept. Unfortunately, at that point in time, the procedural rules were not paved or were not there for Profeco to really exercise these kind of actions. It was until the Consumers Protection Law Reform of 1992, if I remember well, and then until perhaps 2007, really, when Profeco started to initiate class actions. So we do have experience in administrative class actions. If there is time later, we can discuss how it was, how Profeco's attributions as to this respect were applying, because it's going to be another change for Profeco how to address this issue. But I can tell you that there were cases from Profeco that were initiated against mainly aviation entities. I remember cases such as Air Madrid, Aviaxa, Aerolíneas Azteca, where they shut down operations in Mexico. Also many cases relating to construction companies, where I believe even the consumers were, at least in one or two cases, I don't know if there is someone here from Profeco that may clarify this, but even consumers in those cases have been at least once or twice capable to recover some damages, some monetary damages, so which is important to say. And therefore, well, this is something that is not new in Mexico, but we are facing new changes that we will need to see how they will work. What will be the real effects of class actions carried out by administrative authorities? the bill of reforms introduces different kinds of class actions that can be initiated. It does not specify whether a government authority is only entitled to initiate one or two or the three kind of class actions, and perhaps if there is time, it's a little technical, but we can discuss it later. What would I suspect? I think that mostly the government authorities will go for diffuse actions initially. Why diffuse actions? Because you do not need to determine the group of the class initially. You don't require the consent of the individuals to initiate a class action, which is another point. This means that the authorities will have the ability to initiate them on their own without asking individuals whether it's convenient or not to initiate it. The point here is that the real effects of diffuse actions are very limited. According to our new statute, it appears that diffuse actions will not allow monetary recovery from the individuals pertaining of the class. If there are recoveries from diffuse actions, they will go to a fund that it will be administered by the federal courts, by the Consejo de la Judicatura Federal, and that money will go first to pay procedural costs, attorneys' fees if they are, if attorneys are participating here, and then to promote education and an investigation on class action matters, which is very important, obviously, but I think people would like the money in their pockets at the end. So, if naturally the authorities start with this kind of procedures, I think they will have another goal or another key, perhaps to have the players restore things as they were, or obtain substitute enforcement, etc. But they will not go at the end to the pocket. The recoveries will not go at the end to the pocket of the individuals. It would be interesting to see, because the authority will be capable to do it, if they would like to start class actions in a strict sense. Profeco's rules that were enforced before this amendment allowed this kind of. It was a mixture. It is very interesting, the attribution of Profeco before these amendments. But in class actions in a strict sense, the individuals that form part of this class action and that supposedly or allegedly suffered the damage, at the end will be entitled to recover money from the damages suffered. It has other problems, obviously. First of all, to initiate these class actions, you need to, as I said, obtain the consent of the consumers, at least forming part of the first class that will initiate the action. So that would imply authorities like, I know that there's people from COFECO, etc., opening, notifying people, perhaps opening a file and getting signatures, etc., to initiate these kind of actions, which is difficult. And the second point is that these are opt-in, as you have said. These are opt-in class actions where not everyone will have the benefit of the results if they do not adhere to these class actions either during the procedure or after the procedure. So it will be very interesting which will be the effects of this change. If I have time, I have a couple of reflections in general on this new statute that perhaps we can later discuss, and then I will leave the microphone to Omar, who has a very interesting point to discuss on antitrust, which is also a very important matter regarding this reform. What about competition, understood in the trial sense? The judge will be competent. The judge that will be competent will be that where the defendant has its domicile. If you imagine that class actions are supposedly here to benefit people that have been affected from from damages. What if I have suffered the damage and I live in Cancun and I need to sue a company that resides in Monterrey? That will involve a cost, and that will obviously make more difficult to individuals to be encouraged to initiate this kind of class actions. There is the other point relating to the cost that you have said, which has different ways of looking at it. At the end of the day, if we go to one of the articles of the reform, each of the parties will have to pay for the costs as a general rule. There are exemptions, as you have said, but as a general rule, each of the parties will have to bear the cost of the litigation. So for an individual that has suffered damage from a company and want to initiate a class action, it will have to incur in expenses. Perhaps it will not recover the money that he's looking at, and at the end, we'll have to allocate those funds for attorneys to pay for that representation. So that is something that in the practice will be something that I don't know if it has to change or revised, and we will see how it applies. So these are initial points that I wanted to address, and I believe that in these reforms there is one very, very, very hot topic that has to do with reforms to the antitrust law that were also introduced to class action reforms, whereby perhaps the individuals that have suffered from anti-competitive practices could, without necessarily going through administrative procedures with COFECO, initiate not class actions but individual actions, which were not necessarily allowed before. And this is something that I like a lot and that Omar has prepared, and perhaps we can share later.
Thank you, Marco. Omar?
Thank you. Good afternoon. Thank you very much for the invitation. I would like start by saying that, first of all, this class action is a new trend under Mexican law. George has said that in the United States, they have been trying these cases for over 60 years. Well, in Mexico, although we had this authority of the Consumer Protection Agency to start these kind of actions, the reality is that there were 7 or 8 actions brought. They were not really effective, and therefore we need to improve basically private action in this kind of sense. Then what did happen here in Mexico is they inserted the right to start class actions right in the Constitution as a right to access to justice. Therefore, there is no doubt now that every citizen in Mexico have the right to appear before the federal judiciary and invoke federal laws for the specific items that my colleagues have pointed out. By the way, I believe that the question that you said, Eduardo, the wording that the Constitution set forth seems to preclude the possibility to go to arbitration, because they said federal judges and federal laws are going to basically be devoted to try to resolve these kind of issues, even though the 3 or 4 paragraphs behind Article 17 of the Constitution provides at the very same level that ADRs are going to be also launched within the Mexican landscape. Well, the first thing is a constitutional amendment. The second thing is this new class act is going to become effective until February 28th, March 1st next year. That means that we are going to have sufficient time to try to prepare ourselves, to prepare the judiciary in order to shift the way that we try cases in Mexico. When I think and I see class actions, 2 things come to my mind. First, Erin Brockovich movie. I love Julia Roberts in that movie. But the second thing is, I am a father of 3 kids. They invite me on a Father's Day to a gymnastic class. At the very first movement, I broke my ankle. And the professor said, "What happened?" And I said, "Well, I was not flexible enough." And when I see the Class Action Act, I believe it's something similar is going to happen. If I try to enter into this kind of litigation, when the kind of tools that I have been taught for 20 years, what's happening is I'm going to have a legal fracture. I'm going to fracture myself because now the principles are entirely different. As Eduardo said, we have a mix of legislations whereby we brought the American rules, but first tropicalized by the Brazilian mind of Anthony Gide, that he is a great scholar, and other Latin American movements from Colombia and from other countries, and then we brought and we put this at the Mexican style. Then sometimes it's difficult to identify what rule we are going to follow. The Latin American practice, the American practice itself, I don't know, truly I don't know. I will point out that there are at least 5 principles that I identify that differ from the US style, that probably is going to make that class action suits are not going to flourish probably the way that the Congress would like to. First, as you said, George, there is no discovery. I am not saying that should be, but at least there is not, and it's an important driving factor in order to try to settle the cases as soon as the class certification exists. In Mexico, it occurs the opposite. Always you go to trial, and probably at the very end of the trial, you are going to settle. But first, you have to go there. Second, we do not have punitive damages. And for antitrust cases, it's important because, as you know, the antitrust statute, the Sherman Act, prevents for treble damages in case of you are able to prove that there was private or antitrust harm. Third, we don't have jury trial, and therefore everything is going to be put just before a court, before a judge that usually handles, I don't know, probably 900, 1,000 cases a year. Four, we do not have this oral system that allows sometimes more participation of the judge in the way that you have in the US. And 5, we do really need a strong judiciary, more sophisticated, more devoted to this economic analysis that Judge Greensburg was talking about. And the opposite part is also we need more sophisticated attorneys. Trial counsel needs to basically raise the bar as well. And for starting, we do not have a bar association as such. Then I think there are these driving points need to be shaped in order to improve not only the traditional litigation, but also class litigation. What's going to happen with antitrust class actions? Section 38 of the Mexican Antitrust Statute was modified. It's going to start, basically it's going to enter into effect as the Class Action Act. But there is a big problem right now that the practitioners are facing. First is before we have a very clear rule regarding private antitrust actions. If you prove that there was, let's say, antitrust conspiracy, and you were a person who has sufficient elements to bring your action for damages and lost profits, you had to await for the resolution of the Federal Competition Commission that becomes res judicata, and then you go to the courts in order to try to prove what those damages and lost profits were. Right now, the way that Section 38 was modified seems to appear that you do not need to await for a res judicata judgment or a res judicata resolution by the Federal Competition Commission. That's a big problem, because now you are going to put a civil local judge or a federal judge, whatever you choose, because it's a private action. It could be a civil or commercial action. Whenever in the country, you're going to put him exactly in the burden of trying to apply the federal competition law and determine that there was antitrust injury. That's going to be a problem. I believe that something interesting for the courts to do is basically to dismiss those actions and basically to remand that the Federal Competition Commission needs to rule on that before. However, that's not what the statute says.
And they need to resolve.
And they need to resolve. However, regarding class actions, the Congress did a distinction. Specifically, Section 588 said that you need a res judicata judgment or a res judicata resolution by the Federal Competition Authority in order to start the class action. Then you have a clear distinction between a private individual injury and the class action as such. What other problem is going to become? We need to observe, and this is a kind of area, antitrust, where you need to be interacting with other statutes. For example, you need to wait what's going to happen by the end of November with the new way that we are going to challenge the resolution of COFECO, or the Federal Competition Commission. Before, it was very easy. Before, you have a resolution of the COFECO, then you have the opportunity to basically file a challenge within the same entity, and if you lose, you go to the federal courts for the constitutional lawsuits or amparo proceedings. Quite easy. Now, the way it has been modified, the law, you need to go first to start a new proceedings before the judiciary, not an appeal as such, but rather a new proceeding where the Federal Antitrust Agency is going to be sued. Then you're going to have appeal, and then you're going to have direct amparos or constitutional proceedings. What's the relevance of this? That probably these kind of cases are going to take 7, 8 years before it becomes res judicata. And until that point of time, you're going to be able to bring the class action, because that's a procedural requirement set forth on the law. Probably I am out of time. I'm just going to leave 3 additional issues. First, I believe that class action in antitrust matters is probably by practice or by resolutions of the federal judiciary to change a golden rule under Mexican law, the direct and immediate damage. That's a golden rule under Mexican law. However, in antitrust injury, let's think about a conspiracy or a cartel behavior. There's going to be what in the US you have tried, the pass-on defense.
Right.
The pass-on defense means probably you sold the item that was cartelized, but there was an additional or a 2-tier sale to another person, and then the consumer is going to be harmed. But who was the person who caused the harm? The person who cartelized the product, or at the end of the story, you are an indirect purchaser, and the pass-on defense could be considered applicable. Then the golden rule under Mexican law could change. Just to say a couple of additional comments. I don't believe that Mexican law is going to flourish either in private antitrust injury or in class actions lawsuits, because it's very difficult to prove damages, and more difficult to prove it or to prove them when you have individual consumers buying small items. I mean, we need to shift our mind in that kind of issue. And if we do not do that, I don't think that this amendment is going to have the results that we are looking for. I have said in several fora that probably we should think about, probably not treble damages or something like that, but we should think something that like a percentage as it exists in the Mexican property industrial law, where you have the right to sue for at least 40% of the sales of the previous year, because otherwise it's very, very difficult to prove damages. The second comment is that in reality, the way I see the class action amendment is a way to improve the performance of the Federal Competition Commission. Why? Because before, the incentives were to basically breach the law and nothing happened, because fines were low, there was not truly criminalization, down rates were limited, there were not provisional measures, and private antitrust injury has been practically non-existent for 18 years since the Federal Competition Law was launched. Then the shift has been to basically change the incentives. Let's put high fines, criminalize cartel behavior, to have a Mexican version of down rates, provisional measures, class actions, everything all together in order to make difficult to private parties to say, well, I have to break the law, or I should not break it because probably the Federal Competition Commission has limited resources. But if I am caught in the cartel behavior or in any other kind of illegal practice, there will be a high possibility that I'm going to be basically reprimanded and highly reprimanded. That's basically, Your Honor,
Thank you,
what
Omar.
I have to say. Thank you.
We've run over a little bit, so I think that the inter-panel question period will go on for the next 5 minutes, and then we'll open it up to the floor. One thing that Marco mentioned, which I'd like to have him tell us about, is this concept of diffuse actions. It sounds to me like what we're used to in the United States regarding standing requirements, where there's a direct injury to a representative of the class, to his pocketbook, is not going to be a requirement for Mexican class actions, that certain representatives of the people will be able to become activists and seek societal change through class actions. Am I reading this right?
Well, that's an issue, certainly. Let me answer first your initial question. It's rather technical, but diffuse actions are those that the group is broad and is not determined, so you don't have to account them. Secondly, there is not necessarily, it doesn't have to be a legal bond or a legal connection among them, so it's diffuse. That's why it's diffuse. The effects of these diffuse actions is to restore things as they were before the affectation, and if that is not possible, to obtain substitute enforcement, which is, by the way, not defined in the law. And again, there's another chapter in our reforms where you deal with the fund that clearly says that if amounts are collected through diffuse actions, they, as I have explained, and I will not repeat it, they will go to the fund, and ultimately they will not arrive to the pocket of the consumers. Now, that is a question. Obviously, they will have the attribution. The authorities will have the attribution. We suppose that it will be used rationally, and but there are no limits provided in this reform, or in and the attributions that were even granted in amendments that were also included in this package does not provide much rules for them to apply or to initiate these actions.
All right, let's open up we've got 15 minutes, and we'd like to open the floor to questions.
Judge Baez, can I ask a question,
Sure.
of Omar? Omar, your comments were very interesting, but there may be a substantial difference between the U.S. and the Mexican class action with regard to damages. And I just want to make sure I understand you. I've mentioned, too, the provision, as I understand it, of the Mexican Act that requires for individual proceedings. Now, in say in antitrust class actions in the U.S., they most commonly happen this way. The Justice Department brings an antitrust suit and recovers a finding of an antitrust violation by a company, or say a set of companies. They fix prices. Then they don't do it. There's a fine and so forth. But then there is a follow-on action brought by private antitrust attorneys. The Sherman Act provides that the finding of a violation by a government action constitutes prima facie evidence for a private action. So there often are then follow-on actions, but there is no need to show individual damages. That is, typically there will be, where there's a finding of price fixing, there will be one economic expert on behalf of the plaintiffs who testifies, well, the increase in price was this amount. We multiply that times all of the products sold. We want that much money, times 3. And then you have a defendant expert who said, no, it wasn't that much. It was just a little. And there's a battle of the experts, but there's no need to show individual harm in the sense that someone has to go in and say, this is how much of the product I bought. So, for example, after the Microsoft case, you all know that the Court of Appeals for the D.C. Circuit found Microsoft to be guilty of tying arrangements. Actually, there's a very strong reason to believe Judge Ginsburg wrote that opinion, by the way, but put that aside. And I wouldn't say that if he were here, but embarrass him, but I think he did. At any rate, because I've known him for a long time. At any rate, after the Microsoft action, after the government found Microsoft guilty, Microsoft faced over 300 antitrust class actions by different groups trying to recover damages. Now Microsoft settled all of those, but at huge amounts of money, huge, billions of dollars. of money. But they didn't have to show, no one had to say, we bought this many computers. They had to, now, they did it by market, but they looked at Microsoft's sales figures to show how much was sold in Wisconsin, how much was sold in New York, and the like, which made it very easy to recover, obviously, when you have those figures. Now, if each individual member of the class had to come in and say, I bought these, I used Windows for this purpose, and paid this much for it, that would make it extremely difficult. Now, if that's the way the Mexican statute is going to work, I vastly overestimated what its effect is going to be, because that's a very serious evidentiary requirement.
All right.
I think Omar was right on point with respect to the damages. The requisite of standing with respect to the cause, the first requisite, circumscribes the ability to have the certification on the requisite that you show damages, even if it is an action brought by COFECO regarding damages of consumers of services that concern a company who's infringing antitrust law.
But do you have to show them individually, or do you have to show them in aggregate?
If the action is the individually homogeneous, which many can do it individually, but COFECO does it as a group, or the collective action in strict sense, where you have an identified group, such as a union or something, you have to show damages on each individual.
Well, that's going to be very difficult.
Because to liquidate them, you have to show the amount, so there has to be the...
That's probably my main comment regarding that. Probably the class action law is going to probably modify the way that we assess damages and lost profits, because Article 605 provides that once there is the declaration of infringement, then each individual has to go in an ancillary proceeding. Probably there will be 3,000 ancillary proceedings saying that I bought one Microsoft Office software. And then there will be restitution, and probably will be, I don't know if there could be moral damage or lost profits, etc. That will be something similar as to starting 3,000 individual actions. But however, Section 605 is not entirely clear. What I believe, and I completely agree with you, probably there will be a broad estimation that there will be a $500 million basically harm because of this oversale or monopoly rent extracted by the conspirators, and each one probably will have kind of a different estimation depending upon how many it bought. But that's probably one of the most important issues that, in my perspective, it's probably try to revisit the golden rule that we have under Mexican law regarding direct and immediate damage and the way that we are going to prove it.
All right, let's hear from our, can we have a microphone over here, please?
Thank you. Good afternoon. I have two comments that I would like to hear your opinion. The first one is in antitrust matters. For example, in who's going to be the damaged party? For example, in exclusive dealing, is it going to be the distributors? Is it going to be the competitors? Is it going to be the consumers? Is it going to be all of them? No, that's the first question. And the next one is kind of what Omar was talking about, res judicata. I believe there are going to be two issues that will have to be solved in the courts. In Brazil, that is kind of our example for the law, there is a possibility to reopen the cases when there are new evidence. That generates that the companies in the first proceeding, they're going to try to get all the evidence they can find in order to guarantee that there are not going to be new trials and new trials against them. Here in Mexico, that possibility is not established in the law. So there is going to be this double vision. Number one, a company hires a lawyer and says, hey, I believe I can have problems of class actions tomorrow. Sue me, make a little fight, but you lose. No? And that guarantees the company that tomorrow I'm not going to be subject to a new proceeding. And in that same way, maybe I didn't participate in the first one, but I say, hey, I was affected by this company, and I want to sue in a class action or organize a class action. I'm not going to be able to do it. And I believe that is impeding me my right to go to court. I would like to know what you think about it.
I may take the first one if you like, and I don't know if you want to take the second one. It's an interesting your question. It's an interesting one. The Bill of Reform says that only class actions will be can be initiated in relationships of consumption of goods or services, private or public, and environment. So answering your question, I think that that class actions would be available for consumers rather than for other economic agents in a vertical situation. For instance, the distributor, the supplier, would have other tools to initiate actions, obviously, to go with COFECO, perhaps individual actions that have now been introduced and that we have seen the problem. But that is my view as to how, at least, group actions would be available as to the people that may initiate them or benefit. We have said that they can be initiated by the authorities, but at least having the benefit for.
Mm-hmm. Is it possible to think as a competitor, as a consumer of a specific service with respect to antitrust that would make it eligible for class actions? It's difficult to think of an example, but
right. But
the
then
semantics
you will have to comply with the numerosity requirement, or to be represented by COFECO. I think if you are a competitor that was somehow driven out of the market, then you will have a private action. And the way that it is drafted right now, probably you will not even need to go for securing a previous resolution of the Federal Competition Commission. You will go straight and direct. By the way, for me, it's I believe that there are sufficient precedents of the court to say that you need first express declaration of the infringement by the Federal Antitrust Agency, and thereafter to go through for the damages and lost profits. However, the way it was drafted, and specifically the way it repealed a specific paragraph of the previous 38, it's going to cause a lot of problems. And by the way, in class actions, you wanted to avoid forum shopping. By bringing these individual actions, you are going to bring back forum shopping again, because you are going to basically sue whenever you believe that there are, with the state courts, in different places where this, probably think about single economic group of interest. Probably you want to sue the parent company in one place, however you want to sue the specific company that caused the damage in another place.
if I can try to answer
Sure,
a reflection on the second
absolutely.
question, which also relates to what you just said. The perverse incentive that could be identified as a result of the res judicata issue that you cannot reopen the case. In my mind, it's a risky strategy because of the opt-in aspect of the reform. You open a window for people well-informed or attorneys who will inform people who have an interest to jump into the action of the company that's, so it can get out of control. I'm rather more of the idea that you have to have a certainty with respect to the definitiveness of the action, even if you have the 18-month period, which Professor Priest mentioned, to be included individually in the damage phase of liquidation. I think with the problems associated with that month, which were already discussed, it's better to have a closing than to leave it open as in otherwise we can see it on proceedings concerning family, estate, etc. Second, with respect to the res judicata of a decision of COFECO, the conflict between Section 38 as reformed and these reforms, to me as a civil attorney, administrative also, this is a procedural reform of procedural law, the Federal Code for Civil Procedures. This is the special law concerning admissibility of the action. And that should prevail over Article 38, which is the special provision concerning antitrust. To the extent that Article 38 can also be deemed procedural in nature because...
And it could be specialized for antitrust matters.
Then you have a really interesting conflict, and we will see if the criteria that is already prevalent will still stand or there will be any modifications.
Let this gentleman first.
We had a case recently, and it gets on what Omar was saying, and I direct this to George and Omar. A Japanese car manufacturer here in Mexico built its cars, exported 70% to the United States, the rest stayed in Mexico. The airbag didn't work. The person was injured in Mexico, okay? Class action suit been filed in the United States, you know, where the car was, you know, not in Japan or anything like this. The person, the Mexican, happened to be a resident of the U.S. and a citizen of Mexico. Our recommendation was jump on the class action suit in the United States. With this new law coming about in Mexico, if you do have what Marco was saying, you have 30 or more that have an incident with the same airbag and everything like that are not U.S. residents, can they go ahead and file against the home company in the home country, in this case Japan, in a class action suit, and still, because there's no monetary rewards from what Marco's saying in Mexico if you get into it, also have a class action suit in this country?
Do you want me to?
Yeah. I don't really have an answer to that. It's a Mexican question.
I believe that's a common problem that happens every time that a tourist comes to Mexico, rent a car, go to Hertz, and then something happened with the car, and then you go to the parent company to try to sue, and specifically in Texas, because what I was told is a good venue for punitive damages, etc. Usually what it comes, or what we are hired, is for providing affidavits stating that rather the case should be brought into Mexico because the accident occurred in Mexico. There was a Mexican entity involved. It is completely relevant what was the nationality of the person who was injured.
But there's no monetary reward in class action suits from what you're saying here, so it's better to go to the U.S. or go to...
Absolutely. The incentive is to go there because here the golden rule of direct and immediate damage, and especially this very old rule that if you die, you are basically worth 200,000 pesos. That's a complete disincentive to basically sue in Mexico. By the way, yesterday the Supreme Court ruled that there was all limits, or specifically the limits for this kind of injuries that a person suffers, is deemed unconstitutional. That's going to be a big change because otherwise, every time you want to bring the cases in Mexico because you know your liability is basically limited.
Let me just clarify something. There are different types of actions. In those where not monetary recovery for the consumers will be available are only in the diffuse actions. If class actions in strict sense are filed, then the consumers will be entitled to receive. Well, it will depend on the case, obviously, etc. We have discussed the issue of the costs, but indeed we have that tool in Mexico as well. It's just finding which type of action.
We'll take one more question.
Thank you. Two very quick points. The first one, I heard a lot about the need for special juzgados, how do you call that?
Juzgados especializados.
Yeah.
Specialized courts.
Specialized courts to be able to process all this antitrust. I don't know how it turned out in the final statute, but do you think that's granted? Is there a need for that? And the second one has to do with the superpowers of COFECO to come and seize information. So that was creating a lot of fuss, between large corporations thinking that, all their files, related or not to the case, might be seized.
Specialized courts have been already introduced in the last reforms of antitrust law, which were published in May. They will be enforced when the courts are ready to start working. That will be only applicable for federal administrative trial after the procedure at the COFECO has been initiated. But the key point here that Omar was saying is that that would apply as an alternative to challenge COFECO's rulings at the end. But if you initiate not a class action, but an individual court action based on the new reforms of Article 38, those would come to finally a civil court in Veracruz, in Oaxaca, where they do not have any instruction, and that is a big problem.
Specialized courts, I'm sorry, specialized courts are only for the administrative challenging of the rulings of the COFECO. Individual actions could be forum shopping, state or federal courts, but class actions deriving from antitrust actions are basically the exclusive competence of federal district courts in civil matters. Then you will have to deal at the end with 3 different courts.
I'm sorry, I'm going to have to bring this to an end because we're out of time, but Dean, you have a few words to say? Before he says his few words, let's have a round of applause for our panelists.
Thank you. I just want to begin by thanking my good friend Judge Carlos Bayo for moderating our panel not only this afternoon, but our morning panel this morning on antitrust and price squeeze. So thank you, Judge Bayo. And on behalf of the Federalist Society, I'm going to thank all our audience members for your time and attention here. It's been our pleasure to host this conference and welcome you here today. If you enjoyed the conference, and I hope you did, I encourage you to learn more about the Federalist Society by visiting our website online and even consider joining the Federalist Society as a member. I was asked during the breaks and at lunch by several folks if we have a Federalist Society chapter here in Mexico City, and my answer is not yet. So if there's sufficient interest, we'd certainly entertain the idea of beginning a chapter here, and I'd be happy to speak with any of you about that. So once again, thank you all for attending, and we are adjourned.
Thank you.
Thank you very much.
That was fun.
It was fun. Thank you very much. I learned a lot.